Welcome to News Hour by DLC, your one-stop destination for the latest and most impactful updates from the legal world. From landmark rulings to policy shifts shaping the justice system, DLC brings you in-depth coverage, expert insights, and analysis that matter. Stay informed, stay ahead because in law, every verdict counts. Today is 21st April 2025 and we bring you news that matters. The first news for today is as follows. Supreme Court criticizes lengthy submissions in arbitration appeals, calls for time limits. On April 21, 2025, the Supreme Court of India expressed concern over the increasingly protracted nature of arbitration-related court proceedings under Sections 34 and 37 of the Arbitration and Conciliation Act, 1996. A bench comprising Justices Abhay S. Ocker and Pankaj Mithal noted that lengthy oral arguments and voluminous pleadings are undermining the efficiency of arbitration as a dispute resolution mechanism. The court observed that some advocates are treating these proceedings akin to regular civil appeals under Section 96 of the Civil Procedure Code, delving into minute factual details and citing numerous precedents, often of questionable relevance. This practice leads to unnecessarily long hearings and judgments, defeating the purpose of arbitration's intended expediency. Highlighting the narrow scope of judicial review permitted under Sections 34 and 37, limited to grounds such as fraud, bias, or patent illegality, the court emphasized the need for restraint among legal practitioners. It called for the imposition of time limits on oral submissions to prevent the misuse of court time and to enhance the effectiveness of arbitration proceedings in India. Next news, Supreme Court, flawed investigation doesn't nullify prosecution if other evidence is strong. In a significant ruling on April 21, 2025, the Supreme Court of India emphasized that a defective investigation does not automatically invalidate the prosecution's case if other credible evidence substantiates the accused's guilt. The bench comprising Justices Sudhanshu Dhulia and K. Vinod Chandran upheld the conviction of an appellant who challenged his sentence on grounds of a flawed investigation. The appellant contended that his name was added to the FIR belatedly and that witness statements under Section 164 CRPC were recorded only after judicial intervention. However, the court meticulously reviewed the case records and found substantial evidence supporting the appellant's guilt. Citing the precedent set in State Honor v. K. Yarappa Reddy 1999, the court reiterated that even if the integrity of the investigation is questionable, the remaining evidence must be thoroughly examined to ensure justice is served. The court concluded that mere defects or irregularities in the investigation do not automatically vitiate the prosecution's case. If sufficient crucial material is found upon careful examination, a conviction may still be sustained. This ruling reinforces the principle that while investigative lapses are concerning, they do not necessarily exonerate the accused if other compelling evidence exists. Next news, Supreme Court Collegium recommends transfer of 7 High Court judges including 4 from NA. On April 21, 2025, the Supreme Court Collegium recommended the transfer of 7 High Court judges across various jurisdictions, aiming to enhance inclusivity, diversity, and the quality of judicial administration. Details of the recommended transfers: Justice Heman Chandanagodar, NA High Court, Madras High Court; Justice Krishna Natarajan, Na High Court Kerala High Court. Justice Neranahalli Srinivasan Sanjay Gowda, Na High Court Gujarat High Court. Justice Perugu Sri Sudha, Telangana High Court Na High Court. Justice Kasoju Surendar, K. Surendar, Telangana High Court Madras High Court. Justice Dr. Kumbhajadalaman Madharao and High Court Na High Court, Justice Dikshit Krishna Shripad, Na High Court Usa High Court. These recommendations reflect the collegian's ongoing efforts to optimize judicial resources and promote a balanced distribution or judicial expertise across the nation's high courts. Next news. Supreme Court clarifies joinder of parties in arbitration proceedings. In a recent judgment, the Supreme Court of India ruled that an arbitral tribunal can proceed against a party even if they were not served with a notice under Section 21 of the Arbitration and Conciliation Act, 1996, or included in a Section 11 application for the appointment of an arbitrator. A bench comprising Justices P.S. Narasimha and Manoj Mishra emphasized that the absence of a Section 21 notice or exclusion from a Section 11 application does not preclude the tribunal from impleading a party during arbitration proceedings. The court stated that the critical factor is whether the individual is a party to the arbitration agreement. The case involved an agreement between the appellant and respondent No. 1 to form a limited liability partnership, LLP, with respondent No. 3 designated as the CEO or the LLP. Respondent No. 2 disputes arose, leading the appellant to invoke the arbitration clause against respondent No. 1 and file a Section 11 application solely against them. Subsequently, the appellant included respondents No. 2 and No. 3 inches the statement of claims. The respondents contested their inclusion, citing the lack of a Section 21 notice and their omission from the Section 11 application. The Supreme Court held that the tribunal's jurisdiction to add parties is not contingent upon their inclusion in the initial notice or application. The court clarified that the referral court's decision under Section 11 does not conclusively determine the tribunal's authority to implead parties. This ruling reinforces the principle that the arbitral tribunal has the discretion to include parties to the arbitration agreement, ensuring that proceedings encompass all relevant stakeholders. Next news. Supreme Court clarifies possession of substances listed in NDPS Act schedule constitutes offense, even if not in NDPS rules. In a pivotal ruling on April 18, 2025, the Supreme Court of India clarified that engaging with psychotropic substances listed in the Schedule of the Narcotic Drugs and Psychotropic Substances (NDPS) Act 1985 constitutes an offense under Section 8(c) of the Act, even if such substances are not enumerated in Schedule 1 of the NDPS rules. The bench comprising Justices J.B. Pardiwala and Manoj Mishra addressed a case involving the possession of buprenorphine hydrochloride, a substance included in the NDPS Act's schedule but absent from Schedule 1 of the NDPS rules. The trial court had previously dismissed charges under the NDPS Act against the accused, referencing the 2007 Supreme Court decision in State of Uttaranchal v. Rajesh Kumar Gupta, which suggested that prosecution under the NDPS Act requires the substance to be listed in both the Act and the rules. However, the Supreme Court overruled this interpretation, emphasizing the precedent set in Union of India and ANR v. Sanjeev v. Deshpande 2014, which affirmed that substances listed in the NDPS Act's schedule are subject to prosecution under the Act, irrespective of their inclusion in the NDPS rules. The court underscored that the NDPS Act's schedule serves as the definitive list for determining offences under the Act. This judgment reinforces the legislative intent of the NDPS Act to comprehensively regulate and prohibit unauthorized dealings with specified narcotic drugs and psychotropic substances, thereby closing any perceived legal gaps between the Act and its accompanying rules. Next news: Supreme Court rules that overruling judgments apply retrospectively unless specified. On April 17, 2025, the Supreme Court of India clarified that when a subsequent judgment overrules an earlier one, the later decision applies retrospectively unless the court explicitly states otherwise. The bench, comprising Justices J.B. Pardiwala and Manoj Misra, emphasized that such subsequent judgments do not create new law but correct previous misinterpretations, thereby reaffirming the original intent of the law. The court stated, "The judge, rather than being the creator of the law, is only its discoverer." This ruling underscores the principle that legal interpretations clarified by the Supreme Court are deemed to have always been the correct understanding of the law, affecting all relevant cases unless the court specifies a prospective application. Next news: Supreme Court advises caution in remanding income tax cases. On April 17, 2025, the Supreme Court of India emphasized that income tax commissioners should not routinely remand cases under Section 263 of the Income Tax Act, 1961, merely because the assessing officer AO did not make income additions. The bench, comprising Chief Justice Sanjeev Khanna, Justice Sanjay Kumar, and Justice K.V. Vishwanathan, clarified that if an AO, after due inquiry, accepts the assessee's claims without making additions, it indicates the AO's agreement with the assessee's position. The court highlighted that the commissioner must establish both an error and prejudice to the revenue to justify a remand. The revisional power under Section 263 should be exercised by the commissioner through a substantive assessment and, if necessary, making additions, rather than by remanding the matter solely on the grounds of inadequate inquiry. This ruling reinforces the principle that while the commissioner has revisional powers, they must be exercised judiciously and not used to remand cases without clear evidence of error and prejudice to the revenue. And the final news for today is as follows: Supreme Court affirms applicability of res judicata in criminal proceedings. On April 18, 2025, the Supreme Court of India clarified that the doctrine of res judicata applies to criminal proceedings, asserting that factual findings from one case are binding on the same parties in subsequent cases involving identical issues. Live law. The bench addressed the perceived divergence between two lines of precedent. One line, including Pritam Singh and Annar v. State of Punjab 1956, supports the application of res judicata in criminal trials, emphasizing that it would be impermissible to acquit an accused in a later trial based on the same evidence that had previously formed the basis for a conviction. The other line, exemplified by Devendra and Ors v. State of Ud and ANR 2009, and Muskan Enterprises and Annar v. State of Punjab and ANR 2024, pertains to proceedings under Section 482 CRPC, where the court did not decide on merits. The court reconciled these lines by explaining that res judicata applies when a court has rendered a decision on merits after a full-fledged trial. In contrast, proceedings like quashing petitions dismissed as withdrawn do not attract res judicata, as there is no adjudication on merits. This ruling reinforces the principle that parties cannot relitigate issues already adjudicated upon, ensuring consistency and finality in judicial decisions. Thanks for listening and consider subscribing to the channel. Well, that's all for today. Keep listening to Legal News by DLC.